Good morning to all of you. Andarki Shubhodayam. Welcome to Legal Matters by Sai Baba Sukara. Normally, we'll be telling you in the administrative law regarding the principles of natural justice, or in the beginning of the law classes itself, we told you regarding the principles of natural justice, like one should not be a judge in his own cause. Here the other side, which you generally call it as adi alteram partem, like that. Supreme Court of India has commented that High Court of Madras should have followed the principles of natural justice before delivering an order. So, the High Court should follow the principles of natural justice while rehearing the matter. Justice Abhay Srinivas Vokha and Ujjal Bhuyan of the Honorable Supreme Court of India, in the case of M.S.Jaffar sait, SAIT enundi, M.S.Jaffar sait versus the Director of DGP versus the Director of Enforcement, Diary number 35948 by 2024. On 14 May 2025, Supreme Court, while quashing the ECIR, Economic Offences FIR, against Shri Sait M.S.Jaffar Sait, who is the former DGP of Tamil Nadu State. That is in a Prevention of Money Laundering Act case, and observed that or held that the High Court committed error. The High Court erred by not issuing notice to the opposite party or by not following the principles of natural justice. This is very, very important. We did not expect that such topic will come, but it has come. That too at the level of the Honorable Supreme Court of India. అసలు మనం అనుకోం, అయినా సరే జరిగింది. Right. So, when we go to the background story or the brief facts, Mr. M.S. Sait, he was alleged to have illegally acquired a plot from Tamil Nadu Housing Board colony in the year 2011. No doubt, certain governments like Andhra Pradesh, they will issue some house sites to the IAS, IPS officers. Prashasan Nagar in Hyderabad is one such locality. In Amravati also, definitely, after the days go by 10 years or 11 years, we will be knowing that the plots will be allotted to the IPS and IAS officers. So, besides that, this man has obtained a plot in the Tamil Nadu Housing Board Society, which is an illegal thing. Therefore, the Director, Vigilance and Anti-Corruption Bureau, మనకి ఏపీలో అయితే 2 different organizations, Director of Vigilance and Enforcement, Director of Anti-Corruption, there are 2 entities, but in Tamil Nadu, both will be supervised by only one DG officer. The Director of Vigilance and Anti-Corruption Bureau recommended for CBI inquiry. Anyway, ED case has been registered, PMLA, right. So, in 2019, this man approached Madras High Court. Of course, after going to the document and other things, Honorable High Court was pleased to quash the FIR against the DGP. Then what about the money laundering case? He came before the bench of Justice S.M. Subramaniam and V. Sivagnanam. They actually on 21/8/2024, they initially quashed the ED orders or ED's complaint. But Orally they said already FIR has been quashed, so this is also no action on that. Kani, by evening, I think they might have got a rethinking. They posted the matter for rehearing on 23/8/2024. కోర్టులో ఓపెన్గా చెప్పేశారు ఎఫ్ఐఆర్ తీసేస్తున్నామండి, ఈడీ కేసు కూడా లేదన్నారు. బట్ ఈవినింగ్ I don't know the reasons, but they wanted to rehear the matter. So 2 days later, that is on 23/8/2024, they reheard the matter. But in the meanwhile, this man, DGP, ex-DGP, he said that he was not given any notice. Here, the wrong committed by the High Court is visible. The principles of natural justice say, whatever be the reason, whatever may be the cause of rehearing, they should have given a notice, particularly to the DGP. Without that, how can they go for rehearing? So immediately he approached the Supreme Court of India. Supreme Court of India stayed the matter on 6/9/2024. Right. So after staying the matter, Supreme Court of India directed the Registrar of Madras General High Court to conduct an inquiry on what happened, what transpired. ఏమిటిది 27 తారీఖేమో ఆర్డర్ అంటున్నారు, 23 రీహియరింగ్లో తీసేశారు. వాట్ హ్యాపెండ్ అంటే రిజిస్ట్రార్ హెస్ కండక్టెడ్ ఎంక్వైరీ అండ్ సర్ప్రైజింగ్లీ ది ఆర్డర్ వాజ్ డిక్టేటెడ్ ఆన్ 21/8/2024. 23 also, same thing happened. But on 23, rehearing was done. At that time, no notice was given to the so-called DGP, the opposite party. This is the error, or this is the mistake committed by the Honorable High Court. Bench passed the final order on 21/8/24 itself. Writ petition allowed oral directions on the same evening to list it on 23/8/2024. Oral directions కొన్ని సందర్భాల్లో పనికి రావు. So that means Supreme Court says we have no doubt that the petition was allowed, but the recent order was not uploaded. వీళ్ళు ఆ రోజు చేయలేదు, ఓరల్గా చెప్పేసి వదిలేశారు అనేటువంటి అభిప్రాయానికి వచ్చారు. So if the bench wanted to recall, bench అంటే ఇద్దరు కాబట్టి డివిజన్ బెంచ్, if the bench wanted to recall, according to the principles of natural justice, they have to give the notice to the parties, at least to the DGP, which was not done. So the Supreme Court is constrained to quash the ECIR, Economic Offence FIR కూడా తీసేస్తూ they found fault with the High Court. సో కాబట్టి అప్పుడప్పుడు హైకోర్టులో కూడా జరుగుతూ ఉంటాయి. సుప్రీం కోర్టు, సో వాట్ ఎవర్ దే సే ఇట్ ఈస్ ది ఆర్డర్, ఇట్ ఈస్ అల్లా. సో కాబట్టి ప్రిన్సిపల్స్ ఆఫ్ జస్టిస్ మస్ట్ బి ఫాలోడ్ ఇన్ ఈచ్ అండ్ ఎవరీ కేస్. సిపిసిలో చెప్తా, నోటీస్ ఫర్ ఎవ్రీథింగ్ యూ హ్యావ్ టు గివ్ నోటీస్. పబ్లిక్ నోటీస్ ఈస్ వెరీ వెరీ ఇంపార్టెంట్. లైక్ దట్ హియర్, సిన్స్ High Court, even though they did some favor, since they did not follow the principles of natural justice, it was commented badly by the Supreme Court. Please read the case law and enrich your knowledge. With this, I am concluding. Thank you very much.